Hello and welcome. This is module 35 of 36 in paper 10. It is titled Contemporary Conflicts and Possibilities Part 2. And I am Professor Rashmi Raman, which I am sure you know by now. You are at module 35, which means that you are almost at the end of this paper. Let us now look at Contemporary Conflicts and Possibilities Part 2. The learning outcomes of this module are for you to understand the politics and the law behind the invasion of Ukraine by Russia and the secession of the contested territory of Crimea to Russia, and for you to understand the legal and political history of the conflict between Israel and Palestine, to analyze possible conflict resolution mechanisms in the area. The structure of this module is that it begins with an introduction to the situation in Crimea. In the second part, it highlights for you the possibilities and problems of the Israel-Palestine snafu, and then we conclude the module. Contemporary conflicts beginning in the 20th century and continuing into the 21st century may take many forms and may be of many different types. A particular class of conflict may be cases of extraterritorial occupations, similar to the ones seen in the Crimean crisis of 2014 and the everlasting Israel-Palestine conflict, 1948 to present, along with the continuation of more classical forms of occupation. Some of these interventions have given rise to new forms of foreign military presence within the territory of a state. These new forms of military presence have, to a certain extent, refocused our attention on the law and, more importantly, the law and politics of occupation. Crimea. The Crimean Peninsula was the focus of the crisis between Ukraine and Russia in 2014. It is located in the Black Sea and was an autonomous part of Ukraine until very recently. Apart from being separated from mainland Ukraine geographically, the Crimean region is also different in terms of its history and culture, and a large segment of its population is ethnically Russian. Historically, Crimea was a part of the Russian Empire in the 18th century, along with the rest of the ethnic Ukrainian territory, eventually becoming a part of the Soviet Union. Crimea only became a part of Ukraine when the Soviet leader Nikita Khrushchev gave the peninsula to his native land in 1954. One of the main triggers for the crisis involving Russia's alleged annexation of Crimea was the fear that a newly elected pro-Western government in Ukraine would evict the Russian Black Sea Fleet and thousands of naval personnel from their long-held base in the southern port city of Sevastopol, which gives Russia access to the Mediterranean Sea. The subject of the association agreement with the European Union had already created internal fault lines within Ukraine, with the eastern Russian-speaking population opposing the agreement. Eventually, however, Ukrainian President Viktor Yanukovych decided to eventually refrain from signing the association agreement, instead choosing to side with the Russians, of course in exchange for significant discounts on gas supplied by Russia to Ukraine. The protests that followed that decision were violent and bloody, leading to the ouster of President Yanukovych. While an interim government was being established within Ukraine in the days after the ouster of the former president who had fled Russia, a collaboration of pro-Russian Ukrainian groups within Crimea and Russian troops began slowly but surely to take control of Crimea's administration, and they initiated the process of accession of Crimea to the Russian Federation. On 1st March 2014, the Russian Parliament approved of the Russian President Vladimir Putin's request to use force against the territory of Ukraine if necessary to protect ethnic Russians in Crimea. After an apparently farcical declaration of independence by the authorities in Crimea, the Russian troops placed on the border moved in, took control, and ousted any remnants of official Ukrainian authority that remained with the rebel groups. This created a huge international reaction. The international reaction to Russia's alleged intervention in the Crimean region was largely unanimous. The United Nations General Assembly in March 2014 affirmed its commitment to Ukraine's sovereignty, its political independence, unity, and territorial integrity within its internationally recognized borders, underscoring the invalidity of the 16th March referendum held in autonomous Crimea. Many states that participated in the passing of that resolution stated that the referendum had contravened international law, that the United Nations Charter and Ukraine's constitution, both emphasizing that they would neither recognize it nor would the Russian Federation's subsequently illegal annexation of Crimea be given any international recognition. In response, Russia made a number of legally not too strong arguments. Russian authorities maintained that they could not refuse Crimeans their right to self-determination and called on all member states to respect Crimea's voluntary choice to secede from Ukraine and to become a part of Russia. Additionally, Russia attempted to justify its actions by stating that since there was a risk posed to Russian citizens living in Crimea as a result of the political instability and upheaval in neighboring Ukraine, international law in fact permitted Russia to use any measures necessary in order to protect them from the breach of peace or threat to the breach of peace. In terms of international law, the rescue of nationals that are in danger on the territory of another state is partly regarded as the doctrine of self-defense, or alternatively as an unwritten customary exemption of the prohibition of the use of force that is codified in the Charter and provided in Article. The Russian authorities also eventually claimed as a secondary argument that they had been invited by the former president Viktor Yanukovych, that is the president of Ukraine, to intervene in Ukraine. As a general rule of international law, a state can and may invite foreign states and its troops into its territory voluntarily. The classical understanding is that only the official governments, but not opposition groups, are entitled to such request and are entitled also to such invitations. Russia maintained that it was still the legitimate president of Ukraine and therefore possessed the authority to invite foreign troops to intervene. The diplomatic efforts in the immediate aftermath of the alleged annexation of Crimea by Russia were focused on the prevention of the outbreak of fresh violence and open hostilities, and on the setting up of a negotiation process, as opposed to attempting measures aimed at restoring Crimea to Ukraine. The negotiation process held between top US and Russian diplomats was aimed at ensuring that all decisions regarding the future of Crimea involved the Ukrainian government. The discussions revolved around the rights of national minorities and especially ethnic minorities, and an inclusive constitutional reform process within Ukraine that included free and fair elections. An important question that still hovers around this crisis is, what is Crimea's current legal status under international law? The process by which Crimea was incorporated into the Russian Federation involved the use of military force in two stages. First, the military action by unidentified personnel, that is, bearing no official insignia, within the Crimean region who had links with the Russian government. And secondly, the authorized use of military force by the Russian parliament in the form of Russian military troops in order to protect the Russian interests in Crimea, represented by the Russian population who existed within Crimea, who were apparently in danger. This implies a clear violation of the international law principle of territorial integrity and political independence as the bedrock of international law. International law prohibits the use or the threat of use of force. That is, there has been a clear international legal wrong committed by Russia in this regard. Having reached this conclusion, it is automatically implied that there is now an obligation on all other states, all other sovereign states in the world, to not recognize this change in the status of Crimea. Crimea has at no point become an independent state. It could not secede from Ukraine since the narrow legal requirement for a right to secession were not fulfilled. At the same time, it could not annex itself to Russia because it did not fulfill the right of recognition given to it by other states. Because Crimea has not become a state, it could consequently not enter into any treaty relations with Russia, so that its accession to Russia is now without legal effect under international law. This view has been expressed by the UN General Assembly in its resolution on 27th March 2014, where the General Assembly of the United Nations called upon all states in the world not to recognize any alteration to the status of the Autonomous Republic of Crimea and the city of Sevastopol, and refers to the concept of obligatory non-recognition. Thus, from the perspective of international law, Crimea still belongs territorially, politically to Ukraine, whatever the de facto situation may look like. We now come to part 2 of this paper study, that is the question of Israel-Palestine. The ongoing conflict between Israel and the fledgling state of Palestine is quite simply over land. Both the Israeli Jews and the Palestinian Arabs wish to establish their homeland over the same territory, located to the east of the Mediterranean Sea. This conflict began with difficult promises made by the ruling mandate power in that region, that is Great Britain, to grant an independent state to the immigrating Jews as well as to the existing Palestinian Arabs. Over the course of the 20th century, in between attempts made by the United Nations to resolve the dispute diplomatically and peacefully by partitioning the land equitably. Two major wars have been fought between both nations in 1948 and again in 1967. In terms of the political outcomes of these wars, the second war left Israel in control of two large portions of contested Palestinian territory, that is, West Bank and Gaza Strip. As of today, the West Bank is technically in the control of the Palestinian Authority, but under the actual occupation of the Israeli armed forces, which enforce heavy security measures and regulations. Israeli politics and policies and practices in the West Bank and the Gaza Strip have included extensive use of collective punishment mechanisms such as curfews, house demolitions and closure of roads, schools and community institutions. Gaza Strip is controlled by the Islamic fundamentalist organization called Hamas. Although there are no Israeli forces on the ground, the Gaza Strip is blockaded around its perimeter. Both sources of authority have held different stances on the approach for the struggle for self-determination by Palestine, but they have since reconciled in the year 2007 to present a unified front as the Palestinian government. The Palestinians' legal basis for their territorial claims is the fundamental international right that they claim exists, that is, the right to self-determination. Although in the 1960s, the focus of the United Nations in developing the jurisprudence of the international right to self-determination was focused on external self-determination, that is, decolonization, it eventually began to include the Palestinian situation within the framework of this right through multiple resolutions given by the General Assembly. In 2004, the International Court of Justice, that is the ICJ sitting in The Hague, affirmed that Palestinian Arabs constituted a people and that they were entitled to exercise a right. Except the court didn't clearly say whether they had the right to self-determination under the ICJ statute or not. Under the ICJ statute, the International Court of Justice can render advisory opinions to international organizations such as the United Nations on certain points of international law when requested to do so. The General Assembly approached the court on the question of Israel and Palestine. The court ruled that the principles of international humanitarian law and international human rights law applied to the occupied portions of the territory of Palestine, and that the people of this region had the right to self-determination, and that the Israeli settlement through the construction of the wall had encroached into Palestinian territory in the West Bank, and such occupation was unlawful. An important aspect that has always been the subject of widespread academic and public debate is the nature of the peace process operating in this region. Irrespective of the ICJ's decision, which to be fair did not clarify much, the ultimate goal of any effort to achieve peace in the region would revolve around resolving the underlying land dispute and conclusively determining its legal status, a final status agreement. The process in the peace talks has seen multiple ebbs and flows, with some of the major hurdles hindering any tangible agreement being the continued presence and the encroachment through the construction of what is alternatively known as the fence or the security barrier or the wall by Israeli settlements in the West Bank area, and the Israeli refusal to deal with Hamas and the consequent division of Palestinian loyalties among at least two political authorities, Hamas, and the Palestinian Organization. Peace talks primarily stagnated due to the widening gulf of mistrust between the two negotiating parties. From a Palestinian perspective, the United Nations General Assembly's partition plan of the year 1947 recognized that the Arab population, as its legitimate patrimony, could rightfully claim 43% of Mandate Palestine. By reducing it almost by half, leaving them with 22% of Mandate Palestine, only served to deepen their sense of unfairness and outrage that in the aftermath of the 1967 war, where Israel had sought to enlarge the 78% that it was given by the plan, it sought to enlarge the 78% of Palestine it had already acquired by confiscating additional Palestinian territory from the little that was left to them. Israeli leaders so often demand that Palestinians make concessions that match Israeli concessions. It is important to note that Palestinians have not asked Israel to make any territorial concessions, that is, to give up any of the territory that Israel acquired in the War of 1948. Nor has Israel ever indicated it would, under any circumstances, consider doing just that is, giving up territory as a concession. What Palestinians have asked for is that Israel return Palestinian territory on which Israel has illegally constructed settlements and upon which Israel has built its wall and to which it has forcibly transferred its own population in violation of treaty obligations and international law. Additionally, on 29 November 2012, in a vote that went 138 to 9 with 41 abstaining, General Assembly Resolution 67/19 was passed. This upgraded Palestine to a non-member observer status in the United Nations. This attempt by Palestinian authorities to gain de facto recognition as a state was seen by the Israelis as an attempt to subvert peace talks and to pressurize Israel in the international forum. With both sides accusing each other of not being serious about peace negotiations, the process has stagnated since 1948, since the Camp David Accords. The end is nowhere in sight, but in conclusion, this module requests you to analyze the possibilities of resolving this through international intervention. Thank you.